Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today, Ripple has decided to feed the flames of the Ripple v SEC lawsuit. They have tried to step it up a little bit, and we got some really interesting news to cover today. So sit tight, enjoy the video, and make sure you press that like button. Now, before we actually get into it, I want to know from you guys, do you still believe that Ripple will ultimately win? I see a lot of people say, no, XRP actually is a security. It is centralized. What do you guys think about Ripple winning? Yes or no? And also check out the Bybit competition. A link is down below. The people are trading quite properly. It's pretty fun to see. Right now, again, with only a 0.1% profit, you could have actually already been in the top 10. And again, look at how much money these people are going to be winning. It is pretty damn crazy. So once more, join, check it out, links down below, and just read through it for a little second. You'll get to it. You'll understand. All right. Individual defendants filed letter and Pierce and Roisman statements as supporting motions to dismiss amid significant regulatory uncertainty regarding when digital assets may be classified as securities by the SEC. And for those who can't open the PDF, it's also written right here in the statements. Well, I read through it and I'm really interested in all of this. And I really cannot express how excited I get sometimes when I see these things that Ripple posts just because of how relevant they are. And in this specific case here, it is basically Ripple re-explaining why the motion against them specifically, again, I'm not talking about Ripple as a company, but I'm talking about Brad Garlinghouse and Chris Larson, why those motions against them, or the entire lawsuit against them, I should say, should just be thrown out the window. First of all, it doesn't make any sense, right? Logically, it doesn't make any sense that the CEO and founder are now sued. I mean, Jim McCaleb is not even sued, so how, right? Also, I think there's a really interesting kind of discrepancy here between suing the company Ripple and suing the XRP/Ledger/XRP Foundation. The reason I'm saying that is because, theoretically speaking, right, they should sue Ripple, Brad Garlinghouse, the CEO, Chris Larson, the founder, but then also everybody who made XRP to be sold, right, in this exact manner, or how exactly does that work? We have concluded now a couple of times that in this entire journey, XRP is the security itself. It's not the investment contract where XRP is used in that sense. No, it's XRP itself. Isn't then the people who made XRP the people who made for this investment contract to allow, or how? It just doesn't really make any sense why you would sue those two guys if you're not just, why not just sue Ripple? At least to me, it doesn't really make a lot of sense. And a lot of the lawyers over on Twitter also agree with this, and they've also let go of a couple of statements surrounding it. I believe Jeremy Hogan for sure let go of a couple of words. Let me quickly see if I can find those. Here we go. More clear. Imagine you are the judge deciding whether Ripple had fair notice. Right? Okay, pretty obvious. It was violating the law, and you look in the file and see a letter from 2 out of the 5 SEC heads stating essentially that not only Ripple didn't have fair notice, no one had or has fair notice. This is the best piece of evidence we've seen so far on the fair notice defense thus far, and it would be exhibit numero uno in my motion for summary judgment if he were to make one. What a gift for Ripple. And it was handed to them for free by 2, dare I say, brave SEC people calling it how they see it. And these are, again, Roisman and Pierce. We've talked about them a couple of times before. And that's basically the situation right now. It's actually two-part. One, it is a help. So let's say it like this. The top part basically is mostly help, or mostly a summary of why the lawsuit against them shouldn't continue on, which I agree with. And the bottom part here, the last two, is just a letter explaining why it doesn't make any sense to not let Ripple have this fair notice argument, because the SEC is trying to strike it down. And that's also something we came up with a couple of hours ago. I think I showed you guys in a video that there's 4 decisions which need to be made, right? So the motion to intervene from John Deaton, which is going to be last, I think. The SEC's motion to strike Ripple's lack of due process. So that is, again, the motion to strike the fair notice defense, the motion to dismiss, and the motion to compel the turnover. So this last one, it's basically looking like the SEC and Ripple are figuring it out inside. That's basically what we covered in the live stream. The one I think is going to be last, and these two are being tackled right now as we speak, specifically in these letters. So, you know what? We can actually, I think we can just read through them because it's just let's say about 2 A4s-ish. All right. Dear Judge, we write on behalf of Brad Gallhouse and Chris Larson in the above-mentioned litigation to inform the court of supplemental authority that supports the individual defendants' pending motions to dismiss. Right? Okay. Attached in Exhibit Number 1 is a public statement dated July 14th by SEC Commissioner Hester M. Pierce and Ayla L. Roisman in connection with the SEC's settled action with BITRUE Limited, formerly known as CoinSchedule Limited, for violating Section 17B of the Securities Act. The public statement further supports the individual defendant's motion to dismiss for failure to adequately plead that they allegedly aided and abetted Ripple's offers or sales of unregistered securities. In the matter of BITRUE Ltd, CoinSchedule, let's quickly see. All right, so thing number 2. All right. The SEC approved a settlement concerning the respondent's promotion of securities without disclosing compensation in violation of Section 17B of the Securities Act. In a public statement accompanying the resolution, Commissioners Pierce and Roisman, 2 of the 5 sitting commissioners of the SEC, the plaintiff in this action, criticized the SEC's failure to explain which of those digital assets touted by CoinSchedule were securities, an omission which is symptomatic of our reluctance to provide additional guidance about how to determine whether a token is being sold as part of a securities offering or which tokens are securities. Emphasis in original. The public statement confirms the individual defendant's arguments that there was and remains significant regulatory uncertainty regarding when digital assets may be classified as securities by the SEC. Specifically, Commissioner Pierce and Roisman observed that the only certainty we see is that people have questions about how to comply with the applicable laws and regulations. And we're already seeing how these two things line up right now, right? This is really good for the fair notice defense and really good for the motion to dismiss because, well, if nobody could have known, and that is coming from SEC members, then how could Ripple have aided and abetted? And specifically tried to hide the fact that it was security if nobody once more could have known, at least from the SEC's perspective. There is a decided lack of clarity for market participants around the application of the security laws to digital assets in their trading. And this one is also quite significant because if you think about it, it touches upon that little document which we are also waiting for, the freaking deposition of William Hinman and mostly the conclusion surrounding that, whether or not Ripple will be able to ask Mr. Hinman about the deposition's internals or not. But, I mean, it didn't become public today, so let's wait, let's see. With respect to many digital assets, the application of Howey test is not crystal clear. It actually has to be done on an individual basis we talked about before, so it's not that obvious. Although the commission staff has provided some guidance, which is also debatable, the large number of factors and absence of weighting cut against the clarity, the guidance was not intended to offer or wasn't intended to offer. So basically, they're just not clear. Even though they have some guidelines, it's not really that clear. Market participants have difficulty getting a lawyer to sign off that something is not a securities offering or does not implicate the security laws. In this void, litigated and settled commission enforcement actions have become the go-to source of guidance. People can study the specifics of token offerings that become the subject of enforcement action and take clues from particular cases. However, applying those clues to the fact of a completely different token offering does not necessarily produce clear answers. So basically meaning, if you use different cases in the past to build your own case or your own, conclusion, might not completely work. And providing clear regulatory guideposts and then bringing enforcement action against people who ignore them is a better approach than to clue by enforcement approach that we have embraced to date, and that's today's settlement embodies. From that statement, I would kind of think, okay, so they're also kind of providing from themselves a little bit of a hint and heads up that they should just make some clearer rules and some clearer guidelines rather than just suing everybody left and right. In short, we know folks have questions and confusion persist in the marketplace. It is important that we start providing clear and timely answers. I fully and wholeheartedly agree with that. Last one here, it basically just explains once more. As the individual defendant's motion to dismiss establishes, the SEC's aiding and abetting claim requires that it shows that the individual defendants knew or recklessly disregarded that Ripple's offering and sales of XRP required registration of securities and that those transactions were improper. But recklessness is highly unreasonable conduct that represents an extreme departure from the standards of ordinary care to the extent that the danger was either known to the defendant or so obvious that the defendant must have been aware of it. after 2 tries, the SEC failed to adequately plead knowledge or recklessness on the part of the individual defendants. The public statement confirmed that charging the individual defendants with an offense that requires knowledge or recklessness was and is legally untenable. I'm having some difficulty reading this because it's all legal jargon, of course, but the point being clear. Plainly, it could have been so obvious that the individual defendants must have been aware of it years ago that XP was an investment contract, when 2 of the 5 SEC commissioners acknowledged today that the regulatory status of digital assets remains so characterized by a decided lack of clarity that the only certainty we see is that people have questions about how to comply with the applicable laws and regulations. And the other one, we don't have to, I opened it, I got scared. The other one we don't have to read because it's just a letter that they posted themselves, the official one, but you don't have to read this one, all right? It's just once more the SEC basically expressing their opinion. We talked about that before, though. I find it really difficult to see exactly what the SEC sees in opinion. And let me rephrase that. I find it really difficult to see where an SEC opinion can actually kind of be long-lasting. Now, even though Ripple concludes a couple of things out of the previous case of CoinSchedule, I sometimes still wonder if Ripple can actually find that completely applicable or not. And I guess the judge is going to be the deciding factor in all of this because, as it said before in that letter, every case works a little bit differently. However, the most important point about it all is that the SEC has now said from within themselves that the SEC is not being clear and that there's a lot of market confusion. And so this whole motion to depose basically Mr. Hyunman is going to be a lot more interesting now because that's actually where the embodiment of everything is going to be. If that speech was done out of the name of the SEC, then it basically gave the market some expectation, but a really lacking one. And if it was his own opinion, then I really would like to put my hands in the fire to say that the SEC did not do anything to make the market aware of what the current rules and stances of the SEC were, so they didn't do a good job. So this is really beautiful to see. Can't really think of any negative thing regarding that. Here it also said, Ripple executives use SEC commissioners' recent statements to bolster their motion to dismiss, and I must also say, that's some really good legal work right there. If your lawyers are that open and sharp to just see, hey, okay, so SEC put something up, hey, quickly, let's use that within a couple of days already. That's swift, all right? That's some good freaking work. I guess they're being paid royally for it, but still, that's some good freaking work. And if you're wondering, by the way, on July 14th, the SEC announced that it had settled charges against Blotix, the website operator, and agreed a penalty of $150,000 in addition to $43,000 in disgorgement, basically nothing. $200,000 for, I don't know how much money they cost others or what exactly happened right there, but in total, the website had profiled more than 2,500 digital assets. To be honest with you, that's not a really big fine. So, and maybe Ripple is going to be in the ballpark of a fine too, where again, the SEC now knows that the situation has just been unclear. There was more stuff I wanted to cover, but I think we're going to leave it for a different video. We have too much stuff to cover, actually. I can now finally close the chapter, though, of all this legal jargon for today, hopefully. Holy smokes, I've been done and sick with all of that. But yeah, there are a couple more videos coming out. There's a lot of stuff to cover today, so sit tight and enjoy. Make sure you check out the Bybit competition, and once more, see you guys again in another video later today.